Unfortunately, there's no more phones to give away. I don't really have much. Ladies and gentlemen, as I said, my name is Umang Parag from the Public Service Coordinating Bargaining Council in South Africa. It gives me great pleasure to chair another session on such a topical matter that really matters to me as well. The topic is a study of artificial intelligence and its challenges. Without giving away my age, when I was younger, I would hear the alphabets IT and it would bring me great excitement. And now AI is doing a similar thing for me. It really, AI is something that really ruffles my feathers. So I'm really glad to be able to chair this session and to learn from our distinguished panel that we have before us. We recently saw the launch of ChatGPT-4, advanced intelligence, which is more creative and collaborative than any other version before. And it may potentially replace many humans as we know it. I see lots of smiles. Last night we did discuss this at length. We discussed AI for, I think, at least 30 minutes, and we got to Will Smith and the enemy of the state. So it's something that's really topical. It's something that's really a buzz that we actually faced with. And it can be a real problem for academia to actually deal with referencing and these sort of things. So there's a lot of challenges that are associated with intelligence. But enough of my waffling on the subject matter. We have in our midst industry experts who will elaborate on the subject matter. So please allow me to introduce Professor Rajendra Parsad Gunputh and Dr. Beebeejaun Ambareen, the University of Mauritius, with us today. Prof. Gunputh is a professor of law with a chair in international law and the holder of not one, but 2 PhDs with the highest distinction, and is the dean in the Faculty of Law and Management in the university. Dr. Beebeejaun is a law academic where she teaches trust, revenue, company, and insolvency law. So I would hand over to my dear knowledgeable colleagues to advise us further on the subject. Thank you.
Okay, thank you. Yeah, good. Good morning, everyone. I'm Dr. Beebeejaun from the University of Mauritius, and along with my colleague, Professor Gunputh, we are pleased to present our research on a study of the influence of artificial intelligence and its challenges, the impact on employees of the legal sector of Mauritius. So we all agree that technological innovation, in particular, artificial intelligence, are forcing various sectors to transform and innovate, encompassing various disciplines like accounting, finance, medicine, and even law. The huge importance being attributed by governments of several countries on the promotion of AI evidences the fact that there will be soon a greater dependency on data analytical tools that may either aid professionals or simply replace them. For example, the Mauritius Artificial Intelligence Strategy 2018, established by the government, aims at making AI the next cornerstone of the next development model by recognizing the potential of technology to improve growth, productivity, and quality of life. Initially, AI was applied in the legal profession in some non-core areas, which direct at enhancing efficiency or reducing expenses for online services and management systems. Nowadays, AI algorithms are able to interpret human intelligence by collecting, regulating, sorting information, and even imitating the process of legal reasoning. Recently, AI is being used to draft and review contracts through the application identification of law geeks, to identify relevant documents from an opponent in a lawsuit via the application developed by CS Disco, to conduct legal research through Westlaw Edge or Quick Check, and even to predict the outcomes of legal cases by resorting to Lex Machina. Some judges are also adopting AI solutions like Compass to seek advice on bail and sentencing decisions. It has also been witnessed that there is a positive relationship between AI and legal work. For instance, Ross, which is the first AI lawyer developed in 2016, is currently providing its services to an American law firm for the purposes of communicating with lawyers, giving them a beforehand experience of working with future employees, or even providing advice on bankruptcy issues and all. So with such heightened proportion of the usage of AI in the legal sector, this prompts the question of whether robots and AI will replace fellow human beings who are legal experts, or alternatively, if these are being used as aiding tools, what will be the impact on employees from the legal profession? While the majority of research work has focused on the benefits and impacts of AI, little research has been conducted on investigating the effect of adopting AI on employees, to which this current study aims at filling in the research gap. Consequently, the research objective of our study is to assess the influence of AI on employees from the legal profession, mainly in terms of their performance, their reaction and adaptability to change, and to identify the challenges faced by these employees in adopting AI for their operational activities. So, this study has selected Mauritius for conducting the survey, since it is intended to provide some policy recommendations to the official authorities, given that it is an ambition of the government of Mauritius to portray the country as an AI hub. It is therefore imperative to investigate the fears and resistance of employees, since they are the drivers to change and innovation, and thereafter recommend the requisite course of action plans. In order to achieve these research objectives, we have conducted an in-depth, semi-structured interview with one employee from the 13 licensed law firms in Mauritius. So in terms of existing studies, we've got several scholars who categorize AI as some sort of computer science that generate algorithms capable of detecting and utilizing intelligent human behavior. However, the definition of the term intelligent still remains debatable, even in today's digitalized era. As such, AI is quite complex to define, although some common consensus agrees on its various uses and application across multiple sectors. For example, Brooks believes that AI in the legal sector is emerging from machine learning and automation and helps law practitioners to identify new methods of value creation for their clients. The author believes that these facilities enable companies to learn from past experiences and then adapt to their current external environment so as to remain competitive. We have also got Elmarie, another scholar, who mentioned that through the use of AI machine learning tools, lawyers are able to spend less than 5% of their time on review of documents, since these are being catered for by machines, therefore decreasing dependency on labor-intensive methods. Lawyers can thus focus on some other core areas of the legal profession where reasoned judgments need to be exercised, an aspect which machines cannot perform with perfection. Therefore, by reducing the time spent on automated tasks, law practitioners are able to broaden their areas of specialization. So a little glimpse concerning our research design. So like I mentioned, we've conducted an in-depth semi-structured interview with one employee from each of the 13 licensed law firms in Mauritius, and they included managing partners, senior associate jurists, barristers, attorneys, and paralegals. So we had designed 5 questions in particular to assess the understanding of the interviewees on AI legal technologies, to assess the use of AI tools by these law practitioners and employees, to assess their views on the adoption of AI technologies, to investigate on the barriers that impede the adoption of AI tools in the legal sector. And we have also sought their recommendations to make the legal profession become more versatile with AI tools. So a little overview of the profile of our interviewees. So there are 13 interviewees ranging from managing partner, associate, paralegals, and each of these law firms have had a significant number of employees ranging from 50 and up to 100 employees. So above all, our research findings from the interviews conducted highlighted the difference between AI and automation. For example, one interviewee mentioned that automation, such as document sorting or archiving, is a fundamental technological tool being adopted by almost all law practitioners since it is simple and quick to organize. But this interviewee does not term automation as AI. Another interview mentioned that AI corresponds to either machine learning, language processing tools, coupled with the involvement of bulky information to perform some human-empowered skills, such as interpretation. And another interviewee commented that people have the tendency to term all technological innovation as AI, since it is a way of marketing, although not all technology is AI. So in summary, these respondents classified AI for such things that an individual human being would perform by applying some sort of cognitive skill to the task. So concerning the use of AI by law firms in Mauritius, only 4 out of the 13 interviewees made use of AI legal technology to help them in their legal work. More precisely, 2 participants made use of free downloadable software from the internet to predict the outcomes of their lawsuits by inputting the documents and evidential claims that they possess. Following these forecasted results, they said that they were able to enhance and amend the quality of their arguments to secure better chances of winning the law cases. The other 2 interviewees highlighted that their respective law firms have recently acquired some type of specialized software that help in reviewing contracts following the input of a certain amount of basic information. In the true sense, only 4 out of the 13 law practitioners have used AI tools, which represent 31% of the sample population, which indicates that the use of AI in the legal sector in Mauritius is still at its infancy stage. We had also assessed the impacts on law practitioners, and all of the interviewees confirmed that there is a growing demand from clients to innovate and adopt new technology in order to enhance the quality of legal services and to reduce cost. Rather than perceiving AI to be human competitors to replace the labor force, 2 interviewees highlighted that law practitioners need to in fact implement AI solutions to improve business processes and efficiency. Another interviewee emphasized that clients are putting pressure not to adopt AI forcingly, but rather to look out for different means and methods to perform repeated and mundane legal work at lower cost and more quickly. However, one managing partner also mentioned the difficulty in passing the high cost of using AI to clients, since clients are not acquainted with the huge amount of expenses involved to adopt new technologies, and highlighted that clients are less willing to pay for business as usual automated services. So we also noted that the traditional legal structure may become obsolete in the sense that those at the top hierarchical level of law firms usually perform some sophisticated type of legal work, which cannot be replaced by AI, whereas those in the middle may make use of AI tools to help them improve their efficiency. On the other side, employees at the bottom of the hierarchical level usually carry out standardized work, which can then be easily taken over by AI solution. So this will require some reskilling or deployment of staff so as to avoid massive termination of employment contracts. Consequently, the interviewees believe that AI is more disruptive for small law firms that do a lot of bulk work, but less disruptive for those who perform some type of sophisticated legal work where machines cannot replace human. In other words, the use of AI technology implies that the pyramid hierarchy of law firms will be replaced by a more linear one with only partners and associates. The associate scope of work will significantly be reduced since they have their job being performed by machines, but they will have to look for other alternative revenue streams to compensate for the expected decreases in hourly fees, especially for law firms that charge billable hours. It is also imperative to note that all of the 13 interviewees have responded in the affirmative upon being asked if they are ready to adopt AI in their legal work, and they showed no sign of resistance. In fact, several of them are even looking forward to undergo the requisite training to understand and make use of AI. However, there are also some barriers to the adoption of AI. I will go through that quickly so that I can elaborate on the recommendation section, like the threat to autonomy of law practitioners. There can be massive disruptions on business model and also the privacy of clients' information can be compromised because AI technology requires the input of large amounts of data whose privacy can be compromised if there is a bug or a cyber attack on the system. So there is always a fear that clients' confidential information gets leaked, and thus lawyers are faced with additional stress when using AI tools. There is also the difficulty of the high cost of acquisition and implementation of AI technology. And the interviewees highlighted that they need to be given extensive training to understand how AI works and also to be able to make use of these tools, although teething issues are expected to arise at the beginning, and unfortunately, which do not have a place in today's competitive legal sector. So the interviewers were asked about AI and the way forward. They mentioned education and training as the facilitator to adopt AI technology. And they say that they will be able to enjoy higher level of trust and understanding if they understand how AI works and if they perceive AI to be the complementary working tool rather than their replacement. So again, another recommendation brought forward by the interviewees is to enhance employees' faith in the efficiency of AI tools. This is because machine learning has been trained to think and act and provide outcome in a particular way. And the developers have a huge hand in this. For example, some form of biasness by the developers in terms of race, culture, religion can adversely impact on the objectivity of AI tools. And this must be avoided at all costs to ensure a fair delivery to all clients. So the interviews mentioned that a code of conduct may be established for the developers of AI tools. So concerning despite the challenges highlighted by the research, the interviewees are quite positive concerning the emergence of AI in the legal sector. So basically, they say that there is a necessity to shape law students for the basic understanding of how AI machines work and then groom them for adopting AI technologies by combining both legal and technological knowledge. Thus, universities and professional bar vocational exams must now imperatively consider the insertion of AI-related modules in the curriculum. Concerning data security, some additional safeguards considerate with AI algorithms need to be implemented by law firms to protect confidentiality. However, the process can be costly and time-consuming. It is therefore suggested that governments and official authorities provide incentives such as tax deductions for the relevant software development and acquisition. And as mentioned earlier, AI technologies are developed by fellow human beings who, even if not done purposely, may influence the way of thinking of these machines. Accordingly, it becomes necessary to test the fairness status of these AI tools that are being made available on the market. For this purpose, a 2018 commission instituted by the US California state government identified 5 dimensions to consider, mainly autonomy, responsibility, privacy, transparency, and accountability. Additionally, given the proliferation of AI in the near future, there is a need to regulate the design of AI tools and to thereafter monitor their application. It will be convenient for Mauritius to adopt a specific legislation on the development and approval of AI technologies and to test their fairness status. And this law must also provide for the setting up of a national council. This council will be responsible to issue codes of conduct applicable to engineers, developers, and users of AI, to issue guidelines relevant to the development of AI software, approve AI tools, and then monitor their application. So, I think that's all from our side. I thank you for your attention. We will be pleased to welcome any suggestion and question from the audience. Thank you.
Thank you very much, Dr. Ambareen and Prof. Gunputh. It's appreciated. Now, there's an interesting concept, robots replacing lawyers. A very interesting concept, indeed. Thank you for providing a clinical analysis of the subject matter. I'm sure that this has assisted us widely to demystify the subject matter. But AI is such an evolving concept. So let's dive straight in and take some questions from the audience. Please, mics, questions, ladies and gentlemen. Nothing. Thank you. Two.
Okay, so nobody takes the floor until now. Insurance Kent University, I was just a little bit wondering, because to what extent is, you hear a lot about privacy yesterday, and so I just wanted to know, to what extent is there an official organization, institute that is judging all privacy issues? And as a citizens, if you have complaints about privacy issues, or as an employee, who can you approach in that perspective? And if I may, then the third issue is to do that on global static level or something to install, because this is not something which is only, of course, happening in Mauritius or whatever.
Thank you, sir, for that question. The question relates to an official organization that regulates information. If I can speak on behalf of the South African, from a South African perspective, we have an organization which is the information regulator that deals with issues of POPI and PAIA. So we are covered in terms of that, and they deal with complaints as well. So maybe we can get a Mauritian perspective as well. Prof? Yeah.
Just to answer the question, Saif, in Mauritius, we don't have such, but we have regular communication on that. But it is important to emphasize on our section 9 of the Constitution, which provide for right to privacy. We have some landmark cases on the right to privacy. As Dr. Ambareen Beebeejaun explained, that okay, we cannot replace lawyers, firms by robots. We can help us in some way or other. We should not be too archaic with on firms and so forth. Explain also on cyber attacks. Whenever you are in your client, it is face to face. But we don't know, someone might go on Jacob to intervene, to look what is going on, to have private particulars, information about right to privacy. But just to come back, we have only that section 9 of the Constitution. Without going into details about that section 9, but which has been raised in so many cases concerning human beings versus human beings. but we don't have any things about human being versus a robot qui a été défaillant in its objectives, aims, and so forth and so forth. But I repeat again, we cannot be so obsolete. Right now, we are just arrived. They have gone very far. Everybody knows about Japan, Malaysia, these countries which are moving forward with robots, fabrication of vehicles of all types. But maybe AI is more intelligent than us. But one thing we should remember that we control AI. The computer is not going to open by itself. You have to open it to give it directives, orders to go forward. But we are not going away from that question. I don't know any particular legislation or institutional framework which provide for protection to right to privacy. In Mauritius, simple like that. Everything must be simple, but done properly so that we also protect the rights of legal firms and of course their clients.
Thank you for your question. Maybe I will add to what Professor Gunputh has just mentioned. I will turn your question into one of my recommendations. In fact, I was talking about setting up of a council, a national council for AI, for regulating AI tools and giving its approval, testing the fairness status, etc. So maybe one amongst the mandate of this council will be to protect privacy of information as well, that are being circulated via AI tools, and also to regulate the pricing of such expensive, I would say, products. Okay, so thank you for your insightful question and suggestion.
Thank you, Dr. Ambareen and Prof. Gunputh. Ma'am, your question?
Good afternoon. My name is Nikki Wisianel, and I'm from South Africa. I hear what you say about the council and also the privacy issues, the confidentiality issues. But I would imagine that just like when social media burst onto our landscape, there was a need for a lot of deep ethical thinking or deep thinking about ethical issues and professional ethics. I imagine so too with AI. There's going to need to be a lot of thinking about professional legal ethics in that context. So that's just a question.
Yeah, thank you. We take your comment on board. And yes, indeed, the part on ethics is very important. And in fact, the 2018 commission instituted by the US California state government had included ethics in one of its indicators to test the fairness status of AI tools. So that is a good comment from your side. Thank you.
Thank you very much. Thanks, ma'am, for that question as well. I know in social media, there's been such a hype in terms of controversy where people just spill whatever they want to say, thinking that there's no consequences. And we saw people actually go to jail for comments on social media. So I anticipate in AI, we'll see a similar issue that will take place. We have one question, ma'am.
Good afternoon. Thanks once again. My name is Faith Chebet from ENS Africa. Thanks again for a very engaging conversation about artificial intelligence. I think Professor Gunputh has made a very good remark that artificial intelligence has to draw initially from the intelligence of human beings as an initial input. And one of the challenges that we have had in this area in Kenya recently, and we've been involved in cases involving big tech companies accused of hiring low pay workers in Kenya to train AI in terms of filtering very violent content, in terms of filtering, content on abuse, training AI on ethical language. And I think the previous commenter just made a very good point about deep ethical issues around AI. This is something that is very relevant in Kenya right now. I think about 3 of the big tech companies are involved in nasty litigation involving low-paid contractors who've been hired to train AI, including ChatGPT-4 in Nairobi. And I wanted to my question is really to get perspective from the other African jurisdictions, because the accusation out there against the big tech firms is that they're sourcing African labor to train AI And I wanted to understand how is this happening in any of the other jurisdictions? I know South Africa is very advanced in terms of AI, Mauritius as well. I wanted to just understand from your studies if you've come across these issues in your countries and how the big techs can navigate this ethically. Thank you.
Thank you very much, ma'am. In terms of AI filtering to remove any negative information on the internet.
Yeah, thank you for the question. You know, sometimes we speak a lot about the impact of COVID-19 on all key sectors of Mauritius, about its negative impact. I prefer to say that there are also the positive impact. For a very long time, we have been lecturing face-to-face. And soon we shift to that mode on online, Zoom link, Google Meet. And today, myself, very myself, I was not just like so many lecturers, you know, to go online. This is AI. This is a artificial intelligence. A computer replace a lecturer. This has been a very long debate. Just to complete, then there has been a lot of sessions that what we call training of trainers, where we have people in the computer department who train academics, myself including myself, and also online. People choose or Pamhidzai. Michael don't want me to answer to that question. So, okay, we have started to go online. And now, just like other colleagues, we have been trained for that. And now we are going in a blended mode with face-to-face and tutorials and online lectures. This is AI. This is the way we adapt during the COVID-19 because there was a complete lockdown during, I must say, during 2 years, even more than that. And we are having lectures at home. I was on my computer talking to myself in a big house, and we deliver lectures like that. Otherwise, students, and including firms, legal firms everywhere, everybody went online. Of course, there have been some impact, negative impact, where students don't have a computer, etc., but we managed to find a solution to that. Therefore, sooner or later, we will shift to AI.
Yeah, thank you for your question. If I may add to Professor Gunputh's answer. One of the interviews indeed mentioned we need to train the developers, engineers of AI tools, and we need to establish a code of conduct for them. Not everyone can simply come and develop, come up with a new software and name it as AI, especially in the legal services where reasoned judgment is required. So we need to train the future generation and also the existing developers, engineers, and make them abide by a proper code of conduct. Thank you.
Thank you very much. Thanks for providing clarity on that last question. That concludes our session. I'd like to appreciate both Professor Gunputh and Dr. Ambareen. Thank you very much for enlightening us today. Please, can we give them a hand?
Good afternoon, colleagues. Good afternoon. We're almost done for the day. And I know we are standing between you and the lunch break. So this is always a difficult one to go through. But this session is very special, and we're hoping it will be provocative and that it will get us to engage a little bit around labor law and its scope and the boundaries, so to speak, of labor law. It's one that from a personal point of view, you know, affects, it's part of the work that I do at WIEGO, which stands for Women in Informal Employment, Globalizing and Organizing. And one of the questions that we grapple with, particularly if we look at the developing context and if we look at Africa in particular, is how should labor law protect workers? Who should labor law be protecting? If it feels or it seems like a luxury to those that are privileged to be in an employment relationship and oftentimes in what we call a standard employment relationship. So we've been talking a lot about different ways of externalizing and disguising employment. We've talked about how technology affects that. Here we're just going back to the basics maybe of our labor market structures in many African countries. I know countries like Mauritius, South Africa, and Namibia may be exceptions, but in many countries, the majority of workers, the overwhelming majority of workers are perhaps even self-employed workers. And what are the implications of labor laws protection and social protection in terms of these workers? What does it mean for them, and how should we be reconsidering the boundaries of labor law to suit the context and to suit the realities? Because labor law, as we know, is a construct, and one that comes from a particular point in history and in a particular context of the Industrial Revolution, which in many African countries has not quite happened. And when we look at where we are in terms of international policy, international best practice, international instruments, we're talking about decent work. We're talking sometimes about human rights that extend to everyone, that extend to all workers regardless of their status. And so this panel really is going to think about some of these questions in particular contexts and in using different approaches. The three panelists who we have, I'll start with Robinah Kagoye. She is the founder and executive director of Voices for Labor, which is a Ugandan civil society organization that promotes accessible justice to workers through legal aid and representation, strategic litigation, research, advocacy, and training. So she's a lawyer who has expertise in labor law, and before embarking on this journey with her organization, she has worked in the trade union movement. She also holds a Master of Arts degree in Labor Policies and Globalization, as well as a Bachelor of Laws from the University of Makerere. And she has a postgraduate diploma in legal practice from the Law and Development Center in Uganda. So she's currently pursuing an LLM degree. And what she's going to speak about is a particular litigation that her organization has taken on behalf of workers in the informal employment in Uganda, which challenges some of the key pieces of labor legislation for the limitation of their scope to employees in the formal economy. So she's going to talk a little bit about that litigation and how it is going. And then we have Professor Elmarie Fourie, who is an associate professor at the Faculty of Law and the head of the Department of Public Law. She is at the University of Johannesburg, and she's also the director of the Center for International and Comparative Labor and Social Security Law, which is abbreviated to CICLAS. And currently she's the program coordinator for the LLM in labor law and the postgraduate diploma in labor law. She also lectures in labor law and labor law to undergraduate students and postgrads. And she has done a lot of work within the SADC context, so the Southern African Development Community, doing research around the policies and working as a consultant in that regard. And she's widely published in various journals. And Elmarie will be thinking about or looking at the jurisprudential tools that have been used to extend labor laws protection to the informal workers in the informal economy. And particularly, she's looking at intersectionality and discrimination. And then Rachel Moussie, my colleague at WIEGO, and she is a non-legal person, not illegal, but not legal. And she is a social protection specialist who is currently the director of programs at WIEGO. But prior to that, this is a recent development, she has worked in the social protection program, and she came in talking about or working on the child care initiative, which looks at extending child care protection and child care protecting services to workers in the informal employment, particularly in those that work on public spaces. Rachel is from Mauritius and holds an MSc in Development Management from the London School of Economics and a BA from McGill University. She's a citizen of the world. She's lived in many countries and she's now based here in Mauritius. So it's nice to have her here with us. And she's going to talk about a research project that my colleagues and I worked on in WIEGO, which looked at how social protection in particular is extended to self-employed workers, and she'll be providing some very, very worthwhile case studies that may be of interest. So at this point, I'd like to just call upon the speakers to just give their inputs for a maximum of 8 minutes, and then we'll open the floor for discussion. Thank you.
Okay, so I can just talk.
Could the AU team please bring the presentation?
Okay.
That it.
Oh, okay.
Thank you so much for giving me this opportunity. Before I talk about the litigation that we took to court in Uganda, I just want to give a very brief statistical picture of what the informal economy looks like in Uganda. Currently, our informal economy stands at 87%. And that means that our labor force is mainly informal. We are having a very small percentage in the formal economy. And the informal economy, workers in the informal economy are characterized with very precarious working conditions, low wages, decent work deficits, and also they're marginalized. They're marginalized, and most of the work they do, for example, the self-employed workers, for instance, the street vendors, is criminalized. Because of because of our growing economy, informal economy, when we interacted with international lawyers assisting workers on what they would do in Uganda, we proposed that we needed to do something within the informal economy. So before we started this litigation, we undertook an action-based research, which was entirely supported by International Lawyers Assisting Workers, ILO, and the research was about the informal economy and the law, and some of the findings from that research revealed that our constitution, which is the supreme law of the country, is very progressive. It extends protection to all workers without distinction, to all persons without distinction. But then when we analyzed the labor legislations and some other laws, they were categorical on who should be protected. And we started, for example, with the Labor Unions Act in regard to extension of freedom of association to workers. Our Labor Unions Act only limits the enjoyment of the right to freedom of association, to freedom to form or join a trade union to only employees under contract of service. And the labor unions registration regulations also require one to have an employer for you to be registered as a trade union. So in Uganda, we don't have a purely informal economy union, but we have unions that are organizing both formal and informal workers, but they were able only to be registered if they had they only relied on a membership. They presented a membership that would show that they're organizing workers in the formal economy. So they got a chance of being registered, not because they were organizing workers in the informal economy, but because they were able to provide some proof of employer-employee relationship. And then when you look at our Employment Act, it has an exclusion clause in the applicability section where it provides that the act shall only apply to employees employed by an employer under a contract of service, and it excludes the contributing family members and some other categories of workers, and who are basically falling in the informal economy. So some of the recommendations that came from the research, one of it was strategic litigation, advocacy, provision of legal aid, continued research and documentation on the informal economy. But we started with the strategic litigation, and that is why currently we are in court. Now, this petition has 4 parties, 4 petitioners. It's a combination of civil society and some 2 trade unions in Uganda. We have Voices for Labor, we have Platform for Vendors in Uganda, we have the Uganda Markets and Allied Employees Union, then we have the Uganda Artisans and General Workers Union, and it's against the Attorney General, who is the principal legal advisor of the government. As I earlier said, the main grounds in this petition are centered on only 2 main subjects: the denial of the right to form or join a trade union to workers in the informal economy. And here we are looking at, we are challenging Section 2 of the Labor Unions Act, which limits the definition of a labor union to only employees under contract of service. And we are saying it contravenes Article 29, 1A and 43, which gives every worker without distinction a right to form or join a trade union for purposes of representation and collective bargaining. And similarly, Section 3 of the Labor Unions Act, which gives associational rights to only employees, excluding workers who do not have the benefit of being under defined employment relationship. We are also challenging Regulation 5, E4 of the Labor Unions Registration Regulations that require an application for registration of a labor union to be accompanied by the name and address of each officer's employer. And we are saying that is some structural discrimination to those workers who are not in a defined employment relationship. And then the other ground centers around exclusion of workers in the informal economy from employment protection. And there we are looking at the Employment Act, especially the applicability section that only limits the application of the protections and the rights in the Employment Act to only employees who are employed by an employer and under contract of service. And then still we are challenging some sections of the Labor Disputes and Arbitration and Settlement Act that limits, that gives jurisdiction to the Industrial Court of Uganda to only resolve conflicts that arise out of an employment relationship. And also we are challenging the section that gives the right to industrial action to only employees under a contract of service at the exclusion of those who don't have one. And I don't know whether this is relevant, but we also have a second petition, and this second petition centers around street vendors. And here the parties are Voices for Labor, Platform for Vendors in Uganda versus the Attorney General of Uganda and Kampala Capital City Authority. And some of the issues that we are challenging are centered on the ongoing eviction of street vendors that has been very, very chaotic. For those who have been maybe following some news in East Africa, in Uganda particularly, you've seen the brutal arrests and treatment of street vendors, especially the women, because the biggest percentage of street vendors are women. And we have had actually cases where some women have lost their lives in the process of running away from the law enforcement officers. I think 2 years back, we had a very unfortunate story of a woman who was running from a street vendor and fell in a sewage trench, and she was carried away by the water, and she eventually passed on, leaving her minor children. And then we had one who was trying to run away from the law enforcement officers, and along the way, the vehicle ran over her son, and the son passed on. So we thought that street vendors, first of all, when you look at the legislation governing street vending in Uganda, it criminalizes it. And it makes it very impossible to even do street trade legally because it doesn't provide for a flexible or regulatory framework for acquiring a permit. The law makes it very impossible that even if you wanted to acquire a permit, even if you wanted to acquire a license, it is very difficult for you to do so. So we are challenging some sections, some provisions of the ordinances that are being used by Kampala Capital City Authority to criminalize street vending and to brutally arrest the street vendors. But, oh, thank you. I'm out of time, but I'll summarize what we want court to do. Basically, we want court to do two things: to declare the provisions that we are challenging in the Constitutional Court unconstitutional, null and void, but also to make recommendations for labor reforms. And then lastly, we are also being supported. About 9 organizations intend to join as amicus curiae, and they have prepared 2 amicus briefs to support our litigation by bringing in the international law and cooperative law from different jurisdictions on the rights of workers in the informal economy. And the first one is International Lawyers Assisting Workers Network, Institute for Human Rights and Development in Africa, International Commission for Jurists, Africa Regional Office. Then we have the Harvard International Human Rights Clinic. We have Streetnet International. We have Women in Informal Employment Organizing and Globalizing. Then we have local organizations, and that is Initiative for Social Economic Rights. We have FIDA, the Association of Female Lawyers in Uganda. And then we have Strategic Initiative for Women in the Horn of Africa. Thank you.
Good afternoon, ladies and gentlemen, and thank you, Fourie, for this opportunity to present here today. I want to start by congratulating ILO on their recent report around domestic workers and mapping domestic work and discrimination. I think it's a wonderful report, and some of the things that I will state today leads from that. We spoke this morning about the informal economy, and I do not want to repeat anything, but the question arises, how do we protect these workers? Do we merely extend existing legislative provisions like we did in South Africa to domestic workers? And when we do that, we experience challenges because they are covered in theory and not in practice, and therefore I argue they are still in the informal economy. And the reason for that is you merely extending existing legislation that is there to cover those informal employment. And then secondly, what about the design of innovative, tailor-made solutions for these workers, because the nature of their work is so diverse? And there are a number of other ways: voice and representation, legal and economic empowerment. But something came to mind when I read 3 judgments, and that relates to jurisprudential tools. And it's not often in South Africa recently specifically that you read a judgment and you think, wow, I'm going to read this on a Friday evening. It inspires me. It's a judgment that it sounds like poetry. When I say that to the students, they look at me and say, it's not possible. No law can be poetry. But really, if you look at the way these judgments were written, and if you look at the way the courts approached it, I'm so proud to say that I'm a South African. Of course, there are other judgments that are atrocious, but really these are really inspiring. And that made me think, what about using these tools, these things that they mention, to extend protection? And when I spoke to some of the colleagues from other countries here, they said the Magangu judgment already inspired litigation in other countries. So I just want to highlight some of the tools. I do not have a lot of time and won't really go into the facts. But the first judgment deals with street traders, and that's the Makwekani judgment. And we have a 65-year-old informal trader who was responsible for 8 dependents. And what happened here is his goods were removed on a mere suspicion that he doesn't have a permit. And he challenges the Business Act. And the question around this was that the municipality had unfettered discretion. There was no limit to a fine, and there was no due process for these street traders to get their goods back. But what really inspires me is the way the courts looked at the profile of the street trader. So they start by saying, who are they? They are mostly Black Africans, and they are constantly harassed by authorities. And immediately we have a profile of an informal economy worker. They went as far as to say, with this undue process, this unfettered, unlimited powers given to local authorities, this means that this street trader must leave his stall and must try to access courts. They don't have the resources, and every day in court, he's away from his stall and he cannot earn a living. So very important, recognizing the vulnerabilities and the challenges, but then also talking about discrimination. Black Africans previously disadvantaged, coming from poor socioeconomic circumstances. Then we see the start of this interdisciplinary discrimination starting to appear in the court's argument, saying apartheid layered poverty over race. We look at an intersectionality of race and socioeconomic status. For these street traders, their discrimination is ostensible and direct on the grounds of their socioeconomic circumstances. And I think that's the start of recognizing who these workers are. That is the start of looking at them more closely with reference to substantive equality to address their specific needs. The second case, just very briefly, is the South African Informal Traders Forum. We had a new mayor, and you know, when you start a new job, you are a new broom, you sweep clean, and he decided he's going to embark on an operation called Clean Sweep, and he's going to remove all the street traders from the streets. But they did that without asking anyone whether they have a permit or not. So all street traders were removed. But what the courts did here is very interesting. We don't have a right to work in South Africa, but they started to talk about a right to earn a livelihood. And they said by removing these street traders, you impair their right to earn a livelihood. And when you do that, you impair their human dignity, and they face humiliation and degradation. The right to earn a livelihood is closely linked to human dignity. And that is very important. And that's a very important tool when we look at extending social protection to these specific workers. And I think Moussie made a very important comment. He said that when women and government disregard their law, their conduct may very well cause hardship to the most vulnerable amongst us. Once again, identifying these workers as extremely vulnerable. So on the one hand, we have the right to earn money and to support yourselves, but then the court goes so far to say, and your family. It's not just yourself, but you also support your family. And when you can't do that, that impairs your human dignity. And once again, they bring in the humiliation and degradation. But what they did here as well is recognize that human rights are interrelated. And that is so important. When these street traders were removed without due process, they were supporting children. And the court went as far as to say that when that happened, the children suffered. Their rights to basic nutrition, shelter, and basic healthcare services was impaired, clearly recognizing interrelatedness of human rights. And when we talk about the wider concept of social protection, I think that becomes very important. Now, briefly about the Mahlangu judgment, and this judgment really, it's inspiring, because we talked this morning about domestic work, and my colleague said it's undervalued, it's unrecognized. And the court's opening paragraph is, domestic workers are the unsung heroes in South Africa and globally. Immediately, they show such a deep understanding of the work, and they recognize the value of the work. They say, these women leave their children behind to come to the home of the employer to look after the employer's children. By doing so, faster. Okay, by doing that, the domestic worker enables the employer to enter the labor market. And we must applaud the court for understanding that and raising the issue by recognizing this. Once again, who are they? Mostly Black women who were previously disadvantaged. Once again, the court recognized the interrelatedness of human rights, and they talk about evaluating reasonableness. But I think I'll move quite quickly. One of the most important things that they did here was the intersectionality of discrimination. So they say, look at these workers, they're Black women. They come from poor socioeconomic circumstances. So the layers of discrimination are just quite multi-layered. And they also talk about indirect discrimination, and they link that to interdisciplinary discrimination. They are vulnerable. Why? Because they are discriminated on various levels. And the court said this tool of intersectionality allows us to go and look at their circumstances, historical and social. They were previously disadvantaged, and this promotes the notion of substantive equality. So just to sum up, I think these tools are important. Interrelatedness of human rights, and using a tool as intersectionality with reference to these workers can extend protection. Talking about the right to earn a livelihood, link that to human dignity. And I think if we use that, we might be able to extend protection to more workers. Thank you.
Thank you very much for the invitation to be here today. I am now the only person standing between you and lunch, so I will make this quick. I'm going to be focusing today on some research that was conducted at WIEGO by Pamhidzai, Bamu, Laura Alfords, Rutendo Murarikwa, and Theodore Kamwimbi. And it's focusing on the extension of social protection for self-employed informal workers. And given the time that we have, I'm just going to focus on 3 cases, the best practices that we were able to unearth in Ghana, Kenya, and Rwanda. And so Just a bit about WIEGO. We're a global research policy and action network where we work closely in collaboration with workers in informal employment. And this research draws on work done by our law and social protection programs. So as you can see here, and as Pamhi mentioned in the introduction, the informal employment represents 61% of total employment globally. So that's approximately a little over 2 billion people. And within that, self-employment is 64% of informal employment globally. In the region, 89% of total employment is informal in sub-Saharan Africa. And self-employment in sub-Saharan Africa represents 72% of informal employment. And as previous speakers have said, we see that women are disproportionately represented amongst the self-employed, and they are in, there are an equal number of women and men as own account workers, but there are far more women as contributing family workers, some of whom are most of whom are low paid or unpaid. And here the role of employers is interesting. It's that it represents a very small share of the self-employed in the informal economy. So barriers to inclusion in social protection, these have been raised. So I'm just going to quickly go quickly through them. Workers in self-employed workers in the informal economy do not often meet eligibility criteria for social assistance schemes. So they are that missing middle. They have irregular and low contributory capacity for social insurance schemes, particularly among women who tend to be earning less than men within the informal economy. They have a need for short-term access to savings due to higher levels of poverty. So if there's a funeral arrangement to organize, if their goods are confiscated, they need short-term access to funds as well. There's inappropriate registration and payment systems, exclusion from social dialogue, and this was mentioned by our first speaker, in the design and implementation of social protection schemes, and a general limited awareness of social protection schemes. Finally, as we will discuss further, there's a legal exclusion due to their employment status as self-employed. And here a lot of our work at WIEGO draws on ILO recommendation 204. And within that, there are specific clauses looking at the extension of social protection. And it provides a guide as to how social protection laws and policies can be adapted to reach workers within the informal economy, with informal employment. So just quickly on the research methodology, it was a review of 39 Anglophone and Francophone countries surveyed across sub-Saharan Africa. We looked at primary and secondary legislation, policies, and secondary literature, and mainly between the period of March to October 2020. So just in terms of coverage for self-employed in the 19 Anglophone countries in sub-Saharan Africa, you can just get a sense, just looking at this, of the entitlements enshrined in law to get a sense of the gaps. No countries of those 19 had any provisions for sickness. Only 2 had provisions for maternal health protection, not even a maternity benefit, and so on. So that gives you a sense of the gaps. And then what did we see in terms of progress being made? So the report speaks to the fact that national constitutions should be the starting point for implementing international and regional obligations relating the right to social protection at a national level. And the entrenchment of the right to social protection in a constitution represents a constitutional democracy's commitment to a rights-based approach to social protection. 3 approaches were documented. First, some countries have expressly guaranteed the right to social protection, often referred to as social security. This is the case in Kenya's constitution of 2010. Some countries do not expressly guarantee the right to social protection, but do guarantee other rights that are closely related to social protection. And third, these rights may be guaranteed for everyone or for certain vulnerable groups or for a combination of both. And you can see that in the case from Ghana, where the Constitution does not explicitly provide for social protection, the right is implicit. And then the Constitution does guarantee the right to social security to specific vulnerable groups. In Rwanda, Rwanda's Act number 29 from 2017 established the long-term savings scheme, which I'll talk about, for self-employed and informal sector workers as a way to give effect to the provisions of the International Covenant on Economic, Social, and Cultural Rights, which Rwanda had ratified. So, just the first example comes from Kenya. Kenya included self-employed workers in the National Social Security Fund Act of 2013. And what's interesting about this is that the act empowers the responsible chief secretary to make regulations to improve accessibility of the scheme to self-employed workers. So it's not simply allowing for it to exist, but actually tailoring it to the needs of workers in informal employment. So it allows for a minimum contribution as well as an aggregate minimum contribution for the year that considers the self-employed workers' incomes may fluctuate during that year, and they can make more and higher payments during busy periods. The cabinet secretary can issue regulations to waive penalties for voluntary members, so that would include workers, self-employed workers. And most importantly, and this is unique to the Kenya example, there's a representation of organizations of self-employed persons on the board. So that would include, for example, street vendors associations or trade unions of waste pickers, for example. So though that exists in practice, those organizations are not yet represented on the board. And the Kenyan example has operationalized these legal provisions through a mobile platform, and it's called the Haba Haba. And it allows workers in informal employment to make direct payments just using their mobiles. So they can track their contributions, they have a sense of their savings. And it also allows for short-term removal of savings when needed, up to a certain extent. Rwanda's Ejo Heza is a long-term savings scheme, and it provides old age, death, and disability benefits. What's interesting about this scheme is that members can pay contributions based on their capacity, which makes contributions more flexible. It addresses one of the barriers that I referred to earlier. Members can withdraw part of their long-term savings to acquire a house or pay for education or use as a guarantee for a loan. And it allows for incentives through government co-contributions, which are payable once members have saved up specified amounts. So this has been quite an effective scheme in this regard. And finally, the example from Ghana, and this is Ghana's Provident Fund and Pension Scheme. It includes self-employed workers have been integrated into the legal framework of the National Pensions Act of 2008. And they've been incorporated into specific voluntary funded and privately managed provident funds and personal pension schemes, which are referred to as third-tier schemes. It allows for contributions to a separate short-term savings account, and it seems to strike a balance between the protection of future income and access to funds in the short term. But what's interesting about, and I think an important point to raise here, as with Kenya and Rwanda, these three models, they focus on private savings of workers in the informal sector, and they do not allow for long-term co-contributions from the government. They also do not allow for co-contributions from workers in the formal sector. And so they're not strictly social insurance schemes, and that's one of the shortfalls. So to give you an example, the third tier, one of the third tier schemes is run by the Ghana Trade Union Congress and the Union of Informal Workers Associations, When we did the calculations, we realized that the average real value of accumulated savings plus interest comes to about $2,468 over the course of a working life. And that cannot guarantee a decent life on retirement at the age of 60. So there are some real shortfalls there and ways to improve in terms of the design and co-financing of these schemes. Just finally, and this is my last slide, on key findings. What we see, 3 key findings that I want to highlight. First, on integration. The laws need to outline concrete measures and mechanisms to enable self-employed workers to meaningfully participate in social insurance schemes. On social dialogue, it is it's progress, but it's disappointing to see that Kenya was the only scheme that allowed for the meaningful participation of self-employed workers in the governance and decision-making structures of the National Social Security Fund. And finally, what we notice in all 3 of these cases is this combination of primary and secondary laws, which allows for primary laws that establish commitment towards and provide for a broad framework for inclusion while allowing for the detailed modalities of inclusion to be addressed through secondary laws that can be better adapted and amended to the realities of workers in informal employment. So thank you very much for your attention.
Thank you very much to our speakers. I'm going to open it to the floor for some questions, discussion, contributions. Any hands? Okay, we have Dr. Basson in the front. Yvette, thank you. Any other hands? Okay, we have my sister in the second row. Do we have somebody who can help us to man the roving mic? Yvette, do you want to come and grab this mic in the meantime? While we mobilize, aha. Thank you very much, my brother Piri, for stepping up. Thank you.
The question is for me. A National Social Security Fund for South Africa. So that's been mooted for quite some time now, but nothing really has happened meaningfully to get it implemented. Do you think that a National Social Security Fund would help? The way it was described was that you could make irregular contributions and so forth. Do you think that that could be a potential solution?
Thank you very much. We'll take the second question. If there are any other hands up, maybe you can indicate so that we can go through the questions very quickly. I know we all want to go for lunch. Thank you.
Thank you very much for the insightful discussions. And I'm glad to see Kenya up on the screen. My name is Sarah from Kaplan and Stratton in Kenya. I know we are talking about social security, especially looking at it from a government perspective in terms of government helping to secure life after retirement for most workers. I'm just wondering whether there's a space for the private sector to also participate in this and whether we're able to open that up. From the Kenyan experience, in as much as we do have the National Social Security Fund, the public is not, does not trust the government enough or does not trust the NSSF enough to be able to entrust them with their funds during their working life. Recently, there has been a proposal to increase the contributions to the National Social Security Fund in Kenya, and there has been a lot of outcry against it. People would rather opt to secure their retirement through private pension funds than putting their funds with the government. Perhaps we should be relooking at getting the private sector to participate in this. And I don't know whether there are any experiences from other countries or whether there have been studies in this regard that would possibly contribute to that discussion. Thank you.
Okay, thank you very much. Any other hand before we hand over to the panelists? Going once? Going twice? Okay, well, I will hand over then to Elmarie and
Thank you. Thank you for that question. That's a very interesting question. A National Social Security Fund. I mean, we've been talking about for so long and nothing's happened. And there are lots of other things that are happening and nothing is happening, but we talk about it. I would suggest something else, and it's currently being tabled. Let's look at unemployment insurance. They are currently talking about making provision for self-employed workers or workers who want to contribute. Of course, it's problematic for informal economy workers because their income is not every month the same, it's different. So we'll have to make provision for them to contribute irregularly and to make different contributions. I would think that is a better starting point than a national social security fund, seeing that we're battling with the health bill as well. So, and then the distress grant brought something else to the forefront, and that brought to the forefront of discussion about a basic income grant. Isn't that something that we need to revisit? You know, if we look at the distress grant, some of these workers or some of these informal economy workers couldn't work, but they would get the distress grant and later they use that to buy fruit and sell it again. So I wonder if instead of having a national fund, because I don't think we're ready for it, we don't have the infrastructure, start small, look at unemployment insurance, and maybe we must revisit the debates about the basic income grant. That's how I will start.
Thank you for the question. I think you raised a really important point around the lack of trust. So this isn't just a particularity of Kenya. A lot of workers in informal employment talk to us about the lack of confidence they have to give the minimal savings they have over to the government. We have done some work at WIEGO at looking at the possibility of private insurance schemes. Many of them managed, so as in the case of Ghana, by a trade union or by a workers' organizations where there is an embedded sense of trust because they're members of that organization. What we find is that in all of those situations, the contributions are so low and the risks are so high that they're not sustainable financially, those kinds of private insurance models. What we are exploring right now, just yesterday, we had a conversation with AXA about, or they approached us about trying to understand how would they extend their private insurance services to workers in informal employment. That's tricky territory, but it is just to say that there is interest there from private companies who are asking themselves the same questions governments are asking around how do we make contributions, how do we make savings possible, pensions are possible for workers in informal employment, and how do we tailor and adapt those services? So I've given you a social protection answer, but perhaps Pamhi can give you a more legal perspective on this.
Thank you very much. I think I'll echo what Rachel has said. And I guess on the one hand, we have to be sensitive to the realities that the workers face and the challenge that there might be a trust issue. And that is something that, you know, when you legislate, there are always going to be gaps or issues that relate barriers to implementation. And sometimes they may relate to the lack of proper infrastructure to actually operationalize legislation. And sometimes the barriers may come from the very same people that you want to protect. And so those are always issues and challenges that we face in the context of trying to extend workers or trying to extend protection to workers or legislating in general. But I think the principle still remains that being in a situation where we say workers who are self-employed should be excluded from social protection is not a good one. And the point, at least the progress, lies in the fact that, number one, we've actually gotten to the place where we have this kind of legislation. The question then becomes, how do we implement it? How do we make it credible? How do we make it desirable? And part of it also is ensuring that there's representation by the leaders of the organizations that represent these workers to really understand operationally, how is this being done? If they're part of the governance structures, there's a potential for greater confidence in those structures. But generally also we know, even within the private sector, even for someone who is employed, that those issues of trust are there and very much relevant. So I think it's a question of the practice, but also needing to ensure that in principle, the law actually extends that protection. Thank you very much.
Thank you, everybody. And I think the biggest thanks before we start off this afternoon will be going to the Public Service Coordinating Bargaining Council. Thank you very much for a lovely lunch. And as they say in Africa, good food ends up with good talk. So I hope after that lovely lunch, we'll all be awake and present, hopefully not asleep, as we have the last two presentations of the afternoon and also the close of the conference. And I think also from a perspective of bargaining, it's always good to at least feed the parties before they begin so that you have a very conducive manner of negotiations. So PSCBC, thank you very much. This afternoon, I have the honor of introducing Honourable Rashid Hussein. He is the first president of the Redundancy Board in Mauritius, an institute created to ensure transparency in cases of restructuring and closure of companies. And I know globally we have seen a rise in redundancy processes pre-COVID and also post-COVID. And I think it's an apt time that these discussions are had and that we have lessons learned from Mauritius in terms of a body that is specifically dedicated in terms of any disputes or matters arising from redundancies, and probably pick up some of these notes and words of wisdom from the Honourable Rashid Hussein. I would be amiss not to mention that the Honourable Hussein, as explained to us yesterday evening, holds the title of GOSK, which is the Grand Officer of the Star and Key of the Indian Ocean by the Republic of Mauritius. So we are have the gracious honor of having him this afternoon, and I welcome him onto the podium.
Thank you, ma'am, for the kind words. Good afternoon to you all. To the foreign speakers and foreign delegates, I wish you a pleasant stay in Mauritius for whatever is left. I understand there are amongst you who will stay until mid-April. To the fellow Mauritians, it's nice to see you again. I have the pleasure, ladies and gentlemen, to address you on the subject of labor and industrial relations law in a post-COVID Mauritius. Mauritius' colonized past, under French and British rule respectively, introduced French and English law in the island. And while the substantial part of labor law is essentially of French inspiration, our industrial relations law is more English-oriented. Employment and industrial relations matters are governed by the provisions laid down in the Workers' Rights Act 2019 and the Employment Relations Act 2008, respectively, and are applied interchangeably with case law. And whenever we see guidance from either French or English jurisprudence, it becomes Mauritian law. At least it is an exceptional instance when we borrow, we make it ours. With this background, it is important to know the various institutions that regulate employment and industrial relations disputes. There is an industrial court that deals exclusively with matters arising under the Workers' Rights Act 2019, in particular in relation to cases of unjustified dismissal, be it for misconduct or poor performance at work. This court also deals with offences under the Occupational Health and Safety Act 2005. And it goes without saying that there are appellate avenues from the Industrial Court to the Supreme Court, and ultimately to the Judicial Committee of the Privy Council in London. The Ministry of Labour, Human Resource Development and Training has its own mediation service, and any unresolved issues at the level of the ministry may be reported to the Commission for Conciliation and Mediation, which in turn, and upon failure to conciliate the parties, refer the matter to the Employment Relations Tribunal for arbitration. The National Remuneration Board looks into recommendation of minimum salary in certain specific sectors in the private sector, although its existence is now questioned with introduction of the national minimum wage and the imposition of collective bargaining. The Redundancy Board has jurisdiction to decide on the justification of reduction of workforce or closure of enterprise of big corporates. I would like to quote an extract from the theme of this present conference. I quote, "The pandemic's impact has been particularly devastating for Africa due to high levels of inequality, more heterogeneous working conditions, weaker social protection systems, and constricted fiscal space. African economies rely on exports of labor-intensive goods or commodities, as well as tourism-dependent economies have struggled to adjust to volatile and shifting demand. Poverty has increased significantly among working people." Unquote. What about Mauritius? The island has not been an exception to the huge impact the pandemic has had on workers and employers. Government introduced the COVID-19 Miscellaneous Provisions Act 2020 to amend a number of enactments and cater for the impact of the COVID-19 infectious disease and for matters connected, consequential, and related thereto. Similar amendments were also made by way of the Finance Miscellaneous Provisions Act 2020, 2021, and 2022. The provisions affecting all employees, irrespective of remuneration or sector of employment, include Government Wage Assistance Scheme. This scheme is to assist businesses adversely affected by the COVID-19 pandemic to pay the monthly salary of the employees who are at risk of becoming technically unemployed during the confinement or as a result of the impact of the COVID-19 pandemic. Employers in the private sector were eligible. The wage support was applicable in respect of Mauritians in full-time or part-time employment, as well as expatriate employees working in Mauritius. Applications were entertained online on the Mauritius Revenue Authority website. Public officers in the government sector continued to receive their wages. Working from home, Section 17A of the Workers' Rights Act. (2029) has been introduced to formally enable an employer to require any employee, irrespective of remuneration, to work from home with prior notice of at least 48 hours. Restrictions and termination of employment. An employer who has received financial assistance under the Wage Assistance Scheme is not entitled to terminate the employment of any employee during any month in respect of which the employer has received such financial assistance. Termination is, however, still possible on grounds of misconduct or poor performance, provided that the procedures laid down in the Workers' Rights Act are followed. Portable Retirement Gratuity Fund. The payment of monthly contributions into the fund, initially scheduled to 1st January 2020 and later deferred to 1st April 2020, had been postponed to such date as may be prescribed. The objective of the fund is to ensure that a worker who retires benefits from the payment of a retirement gratuity for his length of service with any employer from the date of coming into operation of the fund. The fund will basically safeguard the fundamental rights of the workers in respect of social protection. Provisions affecting employees remunerated at a rate not exceeding 600,000 rupees as basic salary per year, which is roughly 250,000 rands, or some $14,000 per year. Flexi-time. The provisions with respect to flexi-time have been amended to impose on the employer an obligation to give 48 hours prior notice before requesting a worker to work on flexi-time and to enable a worker to request to work flexi-time without limiting such requests to situations where the worker has to care for a child below school age or with an impairment. No night shift allowance for night shifts performed during COVID-19. Employers have been exempted from paying the night shift allowance, which is 15% of the worker's basic wage, for night shifts performed between the 23rd of March 2020 and for such further period as may be prescribed. Deduction of leave by derogation from the provisions of the Workers' Rights Act previously applicable. The employer is entitled during a period of 18 months from 1st June 2020 to withhold 15 days annual leave or such number of annual leave as may be prescribed from the leave entitlements of the worker for the calendar years 2020 and 2021. Such deduction is not possible if the worker has been called by the employer to perform work between 23rd of March and 1st of June 2020. For part-time workers, the annual leave that the employer can withhold is prorated according to the number of days work that the part-time worker performs compared to a comparable full-time worker. E-services, e-pay slip. The Central Information Systems Division App Store is an innovative platform which aims at mastering the different software applications designed and developed by the Central Information Systems Division to redesign the way of working. E-pay slip application was designed for civil service officers that enable its intended users to access their respective pay slips online, anywhere and anytime. EHR self-service portal. This is possible using IT to apply for leaves, vacation, and have a record for leaves. Work access permit, WAP. The new digitalized work access permit system became fully operational since 11th May 2020. The police force was in charge for the screening of the WAP. The system was open for all types of workers, including, that is, public and private sectors, and including self-employed. Other individuals requesting the WAP had to submit documents to justify that they have to go to work. People who had no internet access to submit their applications had done so through citizens' advice bureaus. For applicants who didn't own a smartphone, the WAPs were sent to the bureaus, and thereafter the latter were able to collect their permits. Companies requesting WAPs had to submit to the police a list of the names of employees, their ID and telephone numbers. All those employees who had a smartphone received a QR code directly on their mobiles. With those who did not have a smartphone, their codes were sent to the companies. The police had also received QR code readers from the Mauritius Telecom to carry out necessary verifications. In cases where an individual or company had committed an offense, their WAPs were to be immediately revoked. The WAP was being delivered for the sole purpose of allowing the holder to travel from his residence to his place of work and back Furthermore, any person who would have contravened any conditions attached to this permit would have committed an offense, and on conviction would be liable to sanctions. Some people employed in certain sectors were not required to have WOPs. And the same applied to individuals who had to go to hospitals, pharmacies, and supermarkets. Those employees who were exempted include judges, those with status of judge, magistrates, members of parliament, lawyers, medical practitioners, and pharmacists. I remind you that I'm still referring to the provisions that have been applied during the period of COVID-19. So cases pending before the Commission for Conciliation and Mediation. Any labor dispute referred to the Commission for Conciliation and Mediation between 23rd of March and 1st of June 2020, or pending before the Commission as at 23rd of March 2020, in respect of employers operating in the civil aviation and airport, including ground handling and ancillary services, air traffic control, health, hospital sectors, would be transferred to the Employment Relations Tribunal for determination within 30 days. The idea was that industrial disputes could not linger on, and those cases were transferred to that tribunal for arbitration, so that these disputes can be attended and resolved to within a limited time. And that was an exceptional case because of the period of confinement and the period of COVID-19. Another provision is that was made was with regard to minimum services during strike or lockout. The procedural agreement between employers operating in the transport, customs, electricity, hotel, radio, television, refuse disposal, transport, the main services, main public services, including water supply, and their respective trade unions ought to provide the number of workers, their occupations and departments for a minimum service during any strike or lockout. Before proceeding to a strike or lockout, the trade union or employer has to ensure that the minimum service is actually put into effect. Exemptions from provisions applicable in case of takeover or transfer of undertaking. In respect to the sectors just mentioned, the Minister of Labour, Human Resource Development and Training is empowered to exempt employers in those sectors from the application of Section 67 of the Workers' Rights Act. That is, a new employer has no obligation to consider a worker to be in continuous employment following a transfer or a takeover of the previous employer's trade or business. Where such exemption is allowed, the minister may make provisions for the terms and conditions on which the worker may be offered employment by the new employer upon the transfer of undertaking or takeover of the previous employer's trade or business. Alternative procedure for reduction of workforce. Again, employers engaged in the aviation and port sectors may be exempted from the procedure applicable under Section 72 of our Workers' Rights Act and will instead be subject to a new added section, which is Section 72A of the Act, which inter alia provides that no negotiations need to be held with a trade union or workers' representatives to find alternatives to the said reduction or closure. An employer is required to provide 15 days prior notice to the Redundancy Board before the said reduction or closure. If reasons for reduction or closure are justified, the Redundancy Board may either order a payment of 30 days' wages as indemnity in lieu of notice, or upon the request of the employer and with the consent of the employee, order that the employee be placed on leave without pay for the period identified by the employer in his notification, subject to the condition that resumption of employment will be on new terms and conditions, including pension benefits as may be offered to the worker before resumption of work. An employee who is placed on such leave without pay is entitled to the transition unemployment benefit. Now, if the reasons for reduction or closure are not justified, the Redundancy Board may order payment of severance allowance at the rate of 3 months remuneration per year of service. The use of technologies in support to the above measures has proven to be of paramount importance. During the period of lockdown that followed the outbreak period of COVID-19, and in a bid to ensure continuity in the administration of justice, in particular in the field of labor and industrial relations, quasi-judicial institutions like the Redundancy Board embraced digitalization. During the first few months, the board was operating online due to COVID-19. Applications and notifications of a reduction of workforce or closure of enterprise were entertained online, and preliminary meetings were done via Zoom and video conferencing. The board was functional and operational with the help of technology all throughout the COVID-19. The board tried a case of notification of a company to temporarily reduce its workforce, namely the case of Impact Production Limited, reference RBRN 18-2020, where the employer gave as reason that it was not able to negotiate with its employees due to confinement. The board stated, I quote, "The duty to negotiate to be an onerous one, where the focus should be on discussion of the possibility of entering into a settlement agreement. It should include meetings with personnel to be declared redundant in order to discuss the rationale of the downsizing. Meaningful discussions should cover other roles that may be available in the business. An employer cannot just decide who should stay and who should go without careful consideration through the application of a fair process. Confinement doesn't mean that an employer should bypass its statutory obligation to negotiate and proceed with a process of redundancy on the ground that negotiation is not practicable. An employer must still take such steps towards compliance as are reasonably practical. Indeed, virtual meetings could be held, and it is for the employer to ensure that the workers or their trade unions or representatives to have access to the relevant technology, and that it allows proper negotiation to take place. Where the workers do not have the facility to participate in a video call, the possibility of conducting negotiation meeting by telephone could have taken place, unquote. We therefore see that while public access was allowed, while no physical public access was allowed on the premises of the Redundancy Board, urgent judicial services were being provided via technological communication in a bid to curb overnight massive reduction of workforce. Employers could forward the intention to reduce workforce in a statement of case, and those intended to be dismissed could reply to same via computer or mobile application. We cannot imagine such process of continuity in the administration of justice with regard to employment issues taking place without the use of technology. Mobile phones, hard and software computer facilities, and application like Zoom have been most beneficial. Otherwise, the system would have been paralyzed. No doubt the rapid shift to digitalization during the pandemic gave a tantalizing glimpse of just what is possible when authorities empower their workforces to experiment with bold new approaches. There is, however, unfortunately, the danger, like Professor Gunputh referred to this morning, the COVID-19 was a bad experience, but it has its goodies as well. So the danger is that this momentum of having enjoyed the technology in assisting in the administration of justice, it may stall if we simply lapse back into the old ways of working. Consequently, ladies and gentlemen, in this post-COVID era, Mauritius has benefited in a hybrid work model, which has become the reality for many workplaces. And with this shifting landscape of work, there has been, as we have seen, a series of legal considerations. Indeed, amendments to law were necessary to ensure equitable treatment of employees with protected needs. After all, the COVID-19 pandemic changed the shape of those many workplaces, and flexible arrangements have become the new normal. Ladies and gentlemen, I thank you very much for having listened to me.
Thank you very much, Honourable Rashid Hussain. I think there are a lot of learning lessons that we need to take from the Redundancy Board and strides that have been made in Mauritius in terms of how to create structures for redundancies, processes before you undertake the terminations on redundancies, and approvals using the requisite regulatory authorities and boards related to that. A lot of countries, I know we made strides only during the COVID period and thereafter, but as I was researching on this, I realized that the board was actually created pre-COVID 2019, just before that. So my first question before I put it out there to the participants is that now having the board being created pre-2019, and I think that was just around November, December, and then you come into March, and then the whole globe literally comes to a standstill. And a lot of effects happen to employment, especially countries like Mauritius, which are the biggest foreign exchange earner is tourism. So there are no people coming into the country in terms of coming out, other than, of course, there's the agricultural sugarcane, but tourism is big. So there are no people coming in from a tourism perspective. So of course, they had effects on employment. Now, what did you have to do to reposition yourself as the Redundancy Board, just coming in to make room for any of those changes that businesses had to effect in terms of redundancy?
Thank you. I don't know if you believe in destiny. I mentioned to the members of the legislature at some point in time that the creation of the Redundancy Board 1 month before the start of COVID-19 was like we had an appointment with destiny. And it was hard to imagine that time without the creation of such quasi-judicial body just on time. Otherwise, we would have massive reduction of workforce, closure of enterprises, people all over on the road, social disturbances. That is why we had to rush in setting up whatever technology was required to be able to see to it that while the country was closed down, there was one body that was functioning, was the Redundancy Board. I'm not bragging about it, but that is a fact. There are so many lawyers from Mauritius here who are my witnesses. We were actually working overnight because the companies needed to know what to do with their workers, because the country was at a standstill. Like I said, it is through the technologies that we developed a simple, basic system to allow them to follow the legal procedure of redundancy, but we do it via internet, via telephone, mobile phone, whatever technologies that were available to us. So the start of the starting procedure for redundancy is that as soon as the employer intends, it is a matter of intention. He intends to reduce his workforce on economic ground or structural or similar grounds. He has to go through certain procedure and then notify the board. And as soon as the board receives the notification, we only have 30 days to come out with a judgment, which we call an order. And I'm complaining about it to the legislatures, telling them, you know, we are not robots. 30 days is not enough. We have to do more research. So to look into extending that time. And when we receive the notification, be it closure of enterprise or the reduction of workforce, we were handling the cases online. So the employer could forward to us his intention of reduction or closure. We take that, we forward it to the opposite side, the workers' representatives, trade unions, whatever, and they respond. Except for hearing matters, we had to wait for the confinement to be over. But I can tell you, 75% of the cases did not actually reach the hearing stage. They were settled online. So to that extent, the board was really, I believe, of great assistance to businesses. And that includes tourism as well.
Thank you very much. I think we have time for 2 or 3 questions. Anybody with a question?
No, thanks, Chair, and thanks for the presentation. I just want to check, does the way the redundancy, and I take it, retrenchments are handled, if I may use that word, is that there is no negotiations between the employer and the employee party, if there is a union. The moment the employer contemplates to close down a business or retrench, they go straight to the board. That's the first question. And I'm not sure if I got it clear that seemingly also the employer does not have an obligation to actually employ the employees that he finds in the business that they will be taking over. So there is no minimum protection of the rights of these employees upfront. It will depend on the case that is made at the level of the redundancy board. Thanks.
Hello.
Thank you very much. I do represent the trade union movement from Mauritius. During lunchtime, somebody was telling me, hey guy, there's no need for union in Mauritius. You're in paradise, everything is rosy here. And I told him, no, sir, we've got a lot of challenges. In fact, I don't want to sort of contradict, but I think whatever report we have sent to the ILO, to some other institution, we have to put some record straight. There has not been consultation during COVID period between government and trade unions. A lot of protocols, decision taken without consultation, right? So I want to be consistent in what we've written to the ILO and what we are saying here. Secondly, well, it's true that we are faced with a lot of challenges, definitely. But still, we've got a lot of work to be done. Like, for example, in the legislation 2019 and 8, but there has been a lot of amendment brought, very important fundamental points brought without consult. In fact, when the law was passed, this was the bill, there was consultation. But through the Finance Act, government just passed amendment without consultation. So what I'm saying, there's room for improvement. So a lot of work has got to be done. Now, quickly, there's also the issue of some of the legislation, for example, that has got to be reviewed. And one particular legislation that relates to industrial relations, for example, we talk about rights in terms of conditions of work. But in the public service, there is no collective bargaining. You sign your option form, there is no collective bargaining, and there is a case in front of the ILO. It's not the same situation as in the private sector, because this matter was brought also to the attention of PSCBC. So I cannot keep quiet on that, since you already are aware of complaint we've made to the ILO with respect to one particular law that restricts, that is against Convention 87 and 98 of the ILO on rights of workers. The Public Gathering Act, which is being contested with the ILO in 2006, requested government to amend, which is still somewhere in the drawer. So what I'm saying, I'm going to end here to tell you we managed to fight during this period, not only not consultation, but people in the health sector face a lot of problems as well. We've got people, a lot of burnout, because people working, just working, and there's a shortage of staff in the health sector. So there is a lot to be done as well. So I just want to share this with, especially trade union colleagues from South Africa who talked to me during lunchtime. I just want to clarify this. Thank you very much.
In reply to the question put, the first question, the judge, I believe, referred to procedures, consultation, negotiation with regard to redundancy in general. My intervention today was on the amendments brought to the law to be able to face issues that arose during confinement and during the COVID-19 period. So exceptional measures that were taken because of exceptional difficult time. Now, the issue, generally, the law on redundancy in Mauritius is that negotiation is compulsory. But it is one of the procedures to be followed, to be adopted. The employer is expected to do a whole series of attempts to save the job of the worker, the employee. And having tried all the procedures, that is to say, either to move the employee to another department if it is a group of companies, or to reduce overtime, to come to some sort of an arrangement with the worker, which is not inconsistent with the Workers' Rights Act, so as to avoid the possibility of closure or reduction of workforce. Having attempted all that, and that must be proved before the court, before the board. The board functions as a court of law. Witnesses have to testify under oath. The end result is that our order or judgment is still subject to review by the law lords in London via our Supreme Court here. So to answer your question, is redundancy law in Mauritius, you have to have consultation, negotiation before coming to the board. And the second and last question that was put was in your recommendations that have been on and on for a long while. I'm aware of that, with regards to some important issues and sectors in the public sector where no consultation have taken place between unions and government, right? I can't answer for that. I can only sympathize with you to a certain extent, the law is passed by Parliament, and we only, as president, judges, magistrate, interpret the law. In redundancy, there is bound to have consultation. So if an employer fails to negotiate, well, he should not expect a favorable judgment. But you must keep trying, Mr. Sajja. Thank you very much.
Thank you. I know there's some burning questions out there, but because of time, I would request that maybe you could reach out to the Honourable Rashid Hussein post this. But thank you very much, sir. Very enlightful, and I'm sure we can take up a lot of points in terms of the structure and transparency created through the redundancy process by the Redundancy Board, and then also not being so rigid in terms of when you have all these great plans and all these great structures and legislation behind it, sometimes it requires some readjustment. And I think that readjustment happened in 2020, and we're still readjusting. And sometimes that readjustment requires us to come out of our comfort zones, embrace technology, and then continuous engagement. I know for quite a number of countries, we didn't have to be very strict in terms of we're heading straight to court and we're at loggerheads. Social dialogue still is a critical element through these processes. So let's keep the dialogues going. I love the fact that there's been sharing between Mauritius and South Africa. And I hope that we can continue having these dialogues as we go ahead. So please, can we give a very, very loud applause to Honourable Rashid Hussein. I, this afternoon, also have the great honor of introducing our last speaker. But before I do so, like every good student, we do have feedback forms from the African Labour Law Society, which can be found on the website, African Labour Law Society website. If you scroll to the bottom of the page, there is a feedback session. We would want to know, what have we done right? Also, what have we done wrong? Where can we improve? Do you want us to come to one of your beautiful countries next year? Do you want us to do this 2 times a year? That's the kind of feedback we need. And then also in terms of anybody here who'd want to be a member who isn't already a member, I hope all of us are, but if you're not, please, there's that element of membership. Claire is here, Connor is here, and then there are members also from the committee who are present, who can explain to you what we've been doing over the past, I would say 5 to 6 years, and what we intend to do across Africa. Let's strengthen these networks. Please click and I would say subscribe, but in this forum, I would say feedback and then become a member. So this afternoon, I have the honor to present a very good friend and an honorary member to the African Labour Law Society. He goes where we go. He has traversed more African countries than I have. And I am proud to say that while I was talking to him yesterday, he told me that he's part of some of the stakeholders who are currently looking at reforms in terms of social security in my country. He came and he didn't tell me he was there. So the next time he does come, I'll make sure that I will stalk him and he'll not leave with that. But I'd like to introduce Professor Gregor Streban. He is from the University of Ljubljana. I got it right? Slovenia, and he will be speaking to us on social security and digitalization in the working environment, teleworking in Europe and beyond. So can we please give a big round of applause for Professor Gregor Streban.
Thank you, Georgina, for this kind presentation. Dear colleagues, I'm certain this applause was also because I'm the last speaker of the conference and the only one standing between you and the ocean later on. So my topic would be social security and digitalization. Let me start with some introduction on social security and digitalization as such. As you know, social security systems developed around the presumption, which is no longer valid. And if you look at the ILO conventions, especially ILO Convention number 102 on minimum standards of social security, you will see that the standard beneficiary is a man with a wife and 2 children. Of course, without any reference to digitalization whatsoever. Of course, that presumption is no longer true. We have a lot of mobility. We have different kinds of marriages. In some countries in Africa, even polygamy is allowed, but I've heard that polyandry is not, so distinctions. And every industrial revolution brings challenges to labor law and social security law. It was so in the first revolution with steam-powered factories, the second one with application of science to mass production and manufacturing, the third one starting to digitalization, and the fourth with technologies such as artificial intelligence, genome editing, augmented reality, robotics, 3D printing, and so on. As to digitalization, I was at one conference on digitalization and we discovered that we all have a lover. Yeah, definition of a lover is somebody you're very fond of, something you're very fond of, and you go to bed with and you wake up with, then we have a lover. And that lover is our mobile phone or even a laptop. Imagine, I have left my phone in the bag at the back and I already feel uncomfortable without my lover. So, yeah. Now we can discuss of digitalization of social security, which means that we have digitalized ways to pension provision, healthcare, unemployment benefits, family benefits, nationally, but also internationally. In Europe, a lot has been invested into digitalization of social security with electronic exchange of social security information, whereby all the national institutions in Europe are connected with a special digital framework. And the next step should be ESPAS, which means European Social Security Passport, where you don't have to carry along your European health insurance card anymore, which is just a plastic card, but you will have it on the app. Also, A1 form, if you go to work to another country and you're insured in the first one, so you can show it on the app. That would be the next step. Next thing is digitalization of a workplace. So it means digitalization, how it is covered in Social Security. And we have telework, which is from the office to the office, outside of the office to the customers, has various forms. And telework, a definition of the European Commission in a guidance note on telework is that it's outside of the employer's premises, because it's cross-border, it should be in another member state, and by using the information and communication technology. Of course, the same work should be performed. That's one of the conditions. And also it should be with in agreement with the worker. Okay. Now we have also other notions like hybrid working or telecommuting. You work in the office, you work outside of the office, or remote work, which is not necessarily telework, or working from home, which could also be telework, could also be from outside of your home. I mean, we were all being admittedly not teleworking during this conference as well, replying messages or so. No? So digitalization has mixed the cards in labor environment and social security systems by disconnecting work from the workplace. I usually had a worker at the workplace, and that was a norm. Now the question is, can digitalization of and in social security weaken or strengthen social protection system? So is it a friend or a foe to social security? Now we can discuss the workplace, of course, which is not that obvious as it used to be. We can work from home or anywhere outside of the office, as mentioned. Relating to social security, it could be the question of work injury benefits, or health and safety issues. I mean, are we working now? Are these chairs really ergonomic? And so on, if you go from one conference to the other and your working place or you work telework all the time, so is that the problem? And the question of traditional institutes of individual and collective labor law, of course, like overtime, rest period, holidays, unionization, and everything else has been already tackled with. The new notion is whether you're working or not. And the notion of workation has been construed. So working and being on vacation at the same time. Like, sounds like when I said I'll be working in Mauritius and everybody was laughing, they're working, yeah. Okay, so, you know. So The question is, how much is our time here related to work and how much it is not related to work? What if accident at work happens? So what if I get injured in my room? Was I working? Depending what I was doing, I think that's always the causal link to the accident should be proven. If I was preparing my lecture and then I went down the stairs and broke my leg, okay, maybe accident at work, but if I was swimming in the ocean and then somebody bit me in my leg, then might not be related to work. The question is also, what if I do that for a longer period? Am I still a worker? Am I still under the direction of the employer? Or am I self-employed? Am I bogus employed rather than bogus self-employed? And the same questions can also be addressed to so-called digital nomads, which are, some countries attract people with high skills just to live in their countries, to work from remotely, so telework all the time. And what is their status is also the question. Now, next question, which is the core, is mobility and teleworking. Now, in Europe, we have special regulation on social security coordination, which means that all national social security systems are linked together with unifying measure, and this coordination regulation applies in all member states, and it does not have to be transposed into national law, which at the same time presents a bit of a paradox of a regulation. It is directly applicable in all member states, but it's not visible to the reader of the national norm, because directives have to be transposed and regulations have to be read next to it. So that's one of the issues. So, but coordination rules take as a starting point the place of work, lex loci laboris. So that's the principle where you work, where you physically work, and the Court of Justice of the European Union emphasizes physical place of work, like in the case of Partena. It's also one later case, X, where the court said, yes, teleworking could be an issue, but it's of such a marginal importance that it does not influence the major rule of lex loci laboris. Now, COVID-19 mixed the cards a bit or boosted the digital technologies. And some countries were more restrictive and some were more open. Just to give an example, the colleagues from the University of Vienna in Austria, they encouraged their researchers and professors to work from home, but not to leave the country. Others were more flexible and they said, yeah, you can work wherever you want and we will still count you as you're physically working in our country. So it means they were bluntly disregarding the coordination rules. Okay. And then certain bilateral agreements were concluded between Luxembourg and Belgium, Luxembourg and Germany and some other countries, just ignoring or making specific rules as to social security coordination. Then it was guidance note on telework, which was adopted by the European Commission, a special body, so Administrative Commission for the Coordination of Social Security. And it first relied upon force majeure, and if it's force majeure, then everything is possible. As you know, during COVID, everything was possible. What was not possible before, everything was possible during COVID. And the argument was that that provision should be prolonged and have a long transitional period. And as we don't have force majeure anymore, but we still have that rules on teleworking, because they will last or be effective at least until 30th of June of this year. Okay. Now we have certain exceptions from the lex loci laboris rule, and the one is posting. If you're sent to another country to do work for your employer, you can still remain insured in your country. Of course, there are some limitations. It should not be longer than 24 months. You should remain under the direction of the employer, and you should be priorly insured in the country before you leave. But now with teleworking, we have different kinds of posting. You know, the employer sends you to another country, not to perform a service for this employer, but in another country, like assembly a machine or do some services or training and so on. But the employer can send you to another country to work for him. Okay, that's reverse posting in a sense. You're sent to work for the same employer. But the Commission always argues it should be random. It should not be a stable working pattern. Because if you have a stable working pattern, then it's simultaneous employment in two countries or more. And for simultaneous employment, we have so-called 25% rule, which means if you work in two countries simultaneously and you reside in one of them, and in that country you work at least for 25%, so let's say 2 days a week, then that country is responsible for your social security. Okay, so if you're teleworking for more than 2 days or more, then the competent country for your social security may change. And then we still have Article 16 agreements of that regulation, which means that the countries can always agree differently. It could be for individual workers, for group of workers, for 2 countries, so bilateral, more countries, multilateral, or European Union wide. So that Article 16 really opens up the possibility to the countries. They can do whatever they want as long as they agree. But now there are certain questions relating to cross-border mobility and teleworking. Now, one is jurisdiction shopping. Will employer be interested for you to reside in a low-cost country in a sense of social security costs, main contributions, and then simultaneously work for that employer? That is one of the dangers. The other danger is discrimination, but not discrimination between workers who can telework and those who cannot telework. Because I think we can all telework, but on construction site, it's difficult to telework unless you operate 3D printers from somewhere, I don't know where, but okay. What is discrimination could be between residents and non-residents. In European Union, we have free movement and everybody should have equal access to all the jobs and move freely. But if your social security changes, if you work 2 days from another country, then maybe employers would be more interested in you if you reside in the country, not in the other country. Okay, so might give preference or to workers from that country. And another solution could be changing that 25% rule. And some countries have even agreed on that. I think Austria and Germany already agreed that 40% rule should apply. So you can work from another country, but if it's not more than 40%, then the same country where you work usually is responsible for your social security. Okay. Oh. Now, there is also specific issues regarding teleworking from a third country outside of the European Union, like teleworking from Mauritius to European Union. And I was wondering, just out of very own personal interest, what would be the situation if I break a leg? I don't know, going down this podium. You don't know. We don't do that. Okay. But nevertheless, there should be probably some agreements in place. And there is a convention number 19 on accidents at work equal treatment. And Slovenia and Mauritius have ratified this convention. So Mauritius would have to treat me as their own nationals if it would be considered work injury. So if I'm working. Okay, but let me conclude, not to take too much of your time. So digitalization could, of course, should be taken cum grano salis. It has its advantages, like keeping records, no cloning of claims, as I've heard in some countries. Decisions could be taken more easily, but it has also some challenges or drawbacks or threats. It's not suited for all situations. Mistakes are maybe difficult to correct. Exposure to data reveal, we have discussed all that. Life is more dynamic than legal rules are, and movements have not become more frequent and of shorter duration, but also more unpredictable. And the rules have to be construed dynamically, not petrified in time. COVID-19 boosted the digitalization, but to be honest, digitalization is here to stay, COVID or no COVID, and the law has to be amended. So every revolution or evolution maybe of law modifies labor market and social security protection. So one of the solutions could also be that we stick with one country that is responsible wherever you work or telework. We have similar rules for members or crews on the vessels or air crews, and maybe such things could also be introduced in social security coordination in the future. It might take some time. As you know, law is always a bit behind life, but I think we will get there also with digitalization and social security to find proper solutions. And of course, proper solutions can only be found after a dialogue, and I'm looking forward to the discussion also on this topic at this conference. Thank you.
Thank you very much. Very good, thought-provoking comments on social security, mobility, and then the changing times. Before I open up for questions, I just have a comment and a question. Now, during COVID, I would even say just at the onset, before there were lockdowns in quite a number of countries, because of the fluidity of workers, especially expatriates, especially across Africa, there was movement just before the lockdowns where organizations gave opportunities to their employees to go back to their home countries before the lockdowns happened. Others had the opportunity of staying in whatever country they were working in. Now, in those kind of scenarios, when some of the governments come back post-COVID and now say, you need to have paid social security contributions based on where you were during that COVID period, is that the right way to look at it from both a social and financial perspective? And then my second question is in the overall review of payments of social security in terms of that fund, should it be on the basis of where I undertake that work, that country should benefit, or should it be on the basis of where I will ultimately be enjoying that benefit, where after maybe retirement, I settle down for it, or even during the course of my lifetime while I'm still working, where I eventually decide is my home?
Thank you for these questions. I think you're correct. There were many also missions to retrieve nationals, to repatriate people from the countries when the COVID started, or maybe some decided to stay. And if I may link it to the discussion we had before, the question of where you pay contributions and where you have benefits. I think it's correct that it was said in the morning that it should be dealt with bilateral agreements or multilateral agreements, but you also have a convention, UN Convention on the Rights of persons, of migrant workers and their families, where I think in Article 27, it says that if you are paying contributions, but you don't benefit, then the country should consider repaying you that contributions. And I was checking, I think it was a colleague from Sierra Leone that asked that question, and Sierra Leone signed that convention, but has not ratified it yet. Now, if you ask me about lex loci laboris and posting, and then when you enjoy benefits, do you know where you will enjoy benefits when you retire? So that would be a difficult linking point. But posting is there especially to avoid changing of social security legislation too often. So if you travel to different countries, I think big discussions now we have is on labor road transport workers or air crew. It has been a long time, this discussion. So if you leave your country and you move quite frequently to another countries, that's the question of different rules. And then I think you should have a rule that stabilizes your social security in a way. You don't move, I mean, virtually between different social security systems, and then you made up losing your rights. That absolutely should not be the intention.
I'm opening up to more interesting questions, thoughts, comments. Just before we all run to the beach, please.
I was just thinking because I've seen that you've mentioned about the displacement of the workplace or the shift of the workplace. In digitalization, would you say that there's that shift, or it's just that the workplace definition will have now to be broadened? Because I know, for example, in South Africa, I think in the law, workplace is defined as something to do with collectivity of workers. So if you're teleworking and you're in isolation, probably you would be regarded as someone who's not really in a workplace. But how would you define a workplace? And this also brings out the question of the workers on platform. Could a platform be referred as a workplace? Because this is also something that has been defined in some jurisdiction as regarding as a workplace, the platforms where probably drivers or any other workers are working in. So I would like your 2 cents on that. Thank you.
Yes, thank you. I was referring to separating work from workplace. But workplace can be anywhere. I think it's not just your office place that could be classified as a workplace. You can also work on the roof or different roofs if you're such a profession, or you can work from home. That's also a workplace. And we had discussion at my university whether the employer should provide you safe working environment also at home. So buy you a computer, buy you a desk, a chair, and so on. So I think workplace can be considered and understood in a broad way. Now, can a platform be a workplace? I think we should not engage again into labor law discussion, because maybe workplace might be more important for labor law than for social security law. And as much as interesting the discussion in labor law may be on the workplace and other issues, social security is not that dynamic. I mean, if either you're a worker or a self-employed or a third category, but you're one way or another covered by social security, or should be covered by social security. Yeah.
Thank you, Professor. My name is John Bosco Ali from Freetown, Sierra Leone. I must be practical here, Professor. In some jurisdictions, thousands and thousands of dollars are spent to digitalize the workplace, but the servers are always down. Mobile companies, they say 5G, you pay, you cannot download a page of documents, talk less of 200 pages. Because it's in some jurisdictions, Professor, this is reality. It's just a problem. As I said, the servers are always down. The system is down. And when these things occurs, Prof, then it's very, very, very difficult for the workplace to be digitalized and then to do teleworking. It's a challenge for some jurisdictions, really. A real challenge. And it even happens, even government would have spent so much money for fiber optics. They never work. Millions would have gone to some pockets, and then the work is in, and nobody chased them. So we suffer. That's just a contribution. I'm pretty sure plenty of jurisdictions are facing that. Thank you very much.
We'll take all the questions.
Right, thanks, Professor. Mine is just citing from what you have presented. I quote, "Life is more dynamic than legal rules are." I think it's something that we need to reflect on. Getting lessons from COVID-19 and even going forward to say, how do we ensure that whatever we legalize based on the dynamics of life, how do we then learn and relearn so that we remain relevant and fit for purpose? Thanks.
Thank you, Professor. One question regarding hybrid working. In fact, of course, at times it's served, of course, with COVID, a lot of challenges have taken place in terms of telephone costs, in terms of traveling costs, in terms of water costs, electricity costs, which is savings for employers. Now, when it comes to hybrid, I know when you work from home, it's very easy to say hybrid, but who bears the cost, when it is hybrid? Because employers can't always, at the cost of workers, try to introduce a new, and then you want the employee to be visible always. right? I mean, the burden has got to be shared, definitely. Thank you.
Thank you for all these interesting questions. I'll try to go one by one. The first one, I think, was about spending a lot of money on digitalization and not everybody being digitally literate or using digital technologies. I think we have the same problem because you can digitalize, but then at the same time, you should offer beneficiaries or insured persons or, possibility to get to access that benefits and to access the services you're offering in a digital way. And indeed, it costs a lot of money. Let me tell you that in European Union, the electronic exchange of social security information in all member states should take place 2 years after the new regulation was passed. The new regulation became applicable in 2010, so that means in 2012, the digitalization should take place. But it was completed only this year. And so you see the time span that is needed for digitalization. The second one was that life is more dynamic. Sure, I fully agree. The question is, I think, related to how much shall we regulate and how much shall we maybe construe or interpret the norms that we already have? Because sometimes over-regulating is also not the best solution. We have very strict definitions of telework, or that might also not be fit for purpose. So I think we have to be clever enough to regulate some things, but also to leave something to practice, administrative practice, judicial practice, to fill out that indefinite terms that we use in law. Hybrid work, who is paying for hybrid work? Well, if you have an agreement, it should always be an agreement between employer and employee for homework or remote work. We have in our laws in my country, in the law, homework, but we don't have remote work. But in our faculty, because professors usually work not from home, but from everywhere in the world, we have concluded a contract on remote work. Okay, but then the costs of remote work are usually covered by business trips or whatever. But if you're home working, then, and that is in agreement with the employer, then that is your working place. An employer has to ensure you have a working place that is fit for purpose, which means that we have, of course, the inspector cannot enter your home, the labor inspector, unless you invite him. Or the employer cannot just enter your home and just view how you're living and whatever. We have come up with a solution that you should answer the questionnaire. If you don't have the equipment necessary, then you should take a photo and the specialist of health and safety at work should evaluate that. And then the employer should provide you with a chair or a desk or a computer, also for working at home, or simply you don't work from home. That's an exception. And if employers can save money by not having so many employees on site, then they should invest to having employees off-site. Okay, that was the argument. And we also pay, I think, €2 per day if you work from home. That means for electricity, internet, whatever. I mean, you have internet in any case in your home, but still we pay certain lump sum per day to work from. That was maybe one of the solutions. Thank you.
Thank you very much for that. Just as we close off and thank Professor Gregor, I just want to put out that what you have shared in terms of social protection and also the changes we've had in terms of digital work environment, a lot of learning lessons, quite frustrating for certain countries because we know better, we should do better. But I think from our point of encouragement for everybody here, thank you, first of all, for being here. Thank you for listening and staying awake this afternoon. But then take off in terms of lessons. Throughout the past 2 days, we now know better. And I think every single person in this room has a sphere of influence in your business, in your society, in your ministries, within your trade unions, within every social sphere that you have. Use your sphere of influence to make that change. Change only happens when it starts with you. It sounds very cliche, but that's the reality. If you want that change, then it has to start with you. So go back, take that influence and make it happen. Thank you very much.